Sarah Boone with a suitcase, justice on demand. Lawyers ducking cover, judges standing firm. Brows of justice race, making everyone squirm. Trial.
Well, welcome back to Mo in the Deep End. Your host, Mo, here. And it looks like Sarah Boone and Mr. Owens, her lawyer, would like a mulligan, a redo, if you will. We've got a defendant's motion for new trial. Comes now defendant, Sarah Boone, or as I like to call her, Samsonite herself, by and through counsel pursuant to Rule 3.600 California Rules of Criminal Procedure. Holy shitballs, is he citing case law? I mean, I'm I don't wanna go stand up and look to see if pigs are flying right now, but, I mean, it could be possible. Florida Rules of Criminal Procedure files this motion for a new trial, stating support thereof the following. 1, the defendant was found guilty as charged of second-degree murder on October 25th, 2024. 2, the instant motion is filed, timely pursuant to Rule 3.600. 3, the defendant asserts that she is entitled to a new trial. Has Sarah Boone ever met something she doesn't assert she's entitled to? Under Rule 3.600 on the following grounds, the court erred in ruling that the defendant was not entitled to court-appointed counsel. I believe Judge Kranick took 15 pages in a motion to explain why she was no longer going to be able to have court-appointed, counsel. FAFO, Sarah. It's kind of a lesson we all have to learn sometime. Apparently, you're learning it in your mid to late 40s. 2, the court erred in denying undersigned counsel's multiple motions for a continuance. Cry harder, Owens. Cry harder. I want to see real tears. Teach your client how to cry real tears if you get a new trial. 3, the court erred in failing to grant a new trial when alleged victim, you mean the adjudicated victim, Sarah Boone, has been convicted. He is the victim, not the alleged victim. He is the victim. And that's really what this all boils down to. Sarah's not the victim, and you guys are scrambling to try to find a way to amalgamate some sort of story that will make her the victim. Anywho, caused an emotional outburst in open court in the presence of the jury prior to deliberations. 4, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. Owens, you got 2 chances to voir dire this woman. You had two chances to voir dire this woman to try to, jump her butt about, the fact that she had reconfigurated her opinion, and you did that so clumsily that, you didn't end up with anything, and the state didn't know that she had changed or, modified any of her opinions either. And 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. No, the state was awesome. They incorporated the force. You will keep your hands off the state's rebuttal argument. Argument 1. Trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took the above case because apparently he thought he was going to make some money or get some publicity out of this or write a book out of it. The above case was very complex. Here, we've got something just for Owens right here. It's our world's tiniest violin. We feel very bad for him. All right. The above case was very complex, even for a seasoned trial attorney. I'm going to check X to doubt. He was not seasoned and or battered and or marinated correctly. So I don't know what this gentleman is talking about, but seasoned he did not show. Who was a public defender for the first judicial circuit for years, as well as a thriving private practice. Okay, Owens. It was apparent to undersigned counsel that Miss Boone would be grossly ill prepared and ill equipped to handle a trial in this manner or matter, and or in fact to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111 Florida Rules of Criminal Procedure guarantee that an indigent defendant has a right to self or to appointed counsel. Holy shit balls, you guys, he actually did cite case law. This might be, again, check your outside localities in case pigs are flying. See Bowen versus State, Kelly, or State versus Kelly, and Progeny. Now, the problem with this, Owens, is again, if you had been, I don't know, an observant and functional lawyer, you would have read the case material that, Judge Kranick, the judge under which you would be trying this case, had put on the record regarding his decision to do these things, and read the 15-page motion that clearly delineates that she had exhausted her chances and she was given multiple warnings and multiple reasons as to why she would no longer be allowed to continue to bilk the taxpayers of Florida for more money. There appear to be two exceptions to this precedence. If the defendant physically harms or threatens to harm, grape, battery, or etc., his or her counsel, or if the trial court certifies that the defendant will not be incarcerated if found guilty. Yeah, that's never going to happen, Sarah. Nice try, though. Good idea. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process, which he did. You know what? I'm going to bank on Judge Kranick having done and crossed every, I, dotted every T, and figured this the hell out. Now, that's me. I'm putting my faith in the brows of justice. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that her continued misbehavior would result in a waiver of the right to court-appointed counsel. Are we getting all of our facts from Sarah again? Because it is documented in multiple places and even on live streams of hearings where Judge Kranick basically said, like, you get one more chance and then you're going home without a Frosty or a lawyer. So, Owens, maybe don't take Sarah Boone's word for gospel. Under controlling precedents, failure for the court to appoint trial counsel can result in a motion for a new trial to be granted. See Figueroa Sanabara versus State, Wilson versus State, and Progeny. Under controlling precedent, Rule 3.111 Florida Rules of Criminal Procedure and the Sixth Amendment, the defendant through counsel moves the court for a new trial. Argument 2. The court failed or erred in failing to grant defendant's motion for continuance made by undersigned trial counsel. Well, again, Owens, had you read the motion terminating Sarah's right to a public defender, you would know that the judge in this specifically stated that getting new counsel would not result in her getting a continuance. In fact, that was kind of bold and underlined as, that's not going to happen in my court. Now, I'm sure that Judge Kranick will have, cite law that he will say, no, this is a completely lawful law, and, go pound sand. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for a continuance by new counsel. See Perros versus State, McKenzie versus State, and Jones versus State, and Deal versus State. In the instant case, when the undersigned counsel came aboard, the case was 4 years old, meaning Sarah had access to all this discovery through her many and, beleaguered state's attorneys. She should know what she needs to get out. She should be able to quickly streamline through all cell phone stuff and say, this is what you need. This is BS. I mean, again, you're still taking Sarah's word for that, and I trust that about as much as I trust, a buffet at Baba Yaga's house, but that's what, you guys have chosen to do as your strategery. The undersigned filed his notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. Again, you sold the ride, you sold the monkeys, you sold the crazy-ass Sarah Boone, and you decided, not only do I want a ticket, but I'd like to be the ringleader of this particular shit show. Can't say I feel bad for you. He immediately and aggressively began preparing for trial, like unintentionally and not maliciously. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for a meeting with Miss Boone and attending multiple hearings. Do we need to do it? I had to go to hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for the unforeseen issues arising during trial. A prime example would be receiving hundreds of pages of text from Miss Boone's seized phone. Oh, like the 500 pages of medical documents you wanted to throw on the state? Kettle, meet pot, cry harder. Viewing all records prior contact of Miss Boone and the victim, not the alleged victim, the victim, with law enforcement, including inadmissible hearsay that the victim told to law enforcement regarding Miss Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for a trial, but due to a short time frame, even with the assistance of other attorneys, was simply logistically unable to be prepared for trial as he would like to be, and Miss Boone is entitled to. Is there anything on this earth that Sarah Boone doesn't think she's entitled to? I mean, am I allowed to breathe air, or does Sarah feel like she's entitled to it? Because she sure as hell felt entitled to murder George, to put him in a suitcase to teach him a daggone lesson. So maybe cut down on the entitlement, because Sarah is like the most unliked person in trial history, basically. But no, continue to explain to us what Princess Sarah is entitled to. Under controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. And then we get to argument 3, in which the douche offlows, from which the absolute could you not read the room any harder Owens has commenced. Argument 3, the court erred when it was denied a motion for a new trial due to an emotional outburst in the presence of the jury. Owens, you already look like the biggest asshole in the entirety of humanity for the way you went after George's family after his mother, heartbreaking, decided that she could not deal with that doggone video. You know, she thought she could, but grief is like a tsunami and it will take your legs out from you. And Owens, maybe you're lucky enough to never have lost someone and to feel these, grand depths of emotion, but it will physically double you over. Her heart was screaming. She didn't scream, she didn't wail, she didn't gnash her teeth and pull her hair and pull out a sackcloth. No, she bent damn near double with the pain in her heart. She tried to stifle her emotions and walk out so that she would not be a distraction. So please put this in your motion. Show the world exactly who you and your particular client are. Because you know what? After this, I don't think anyone's going to suffer the delusions of Sarah victimhood ever again. You cannot read a room. This was the most vile and disgusting thing I have seen in a courtroom. And I've been watching trials for about 3 years. I watched the Business. I watched the Letitia Stout case. I've watched a bunch of, absolute BS go on in court, but I have never seen a quote unquote well seasoned, battered, and marinated attorney stand up like a freaking girl in Hot Topic being told by her mom she can't have, ear gauges. They were crying in my 7. I have never seen that. And the absolute disgust that most of us, streaming or just watching the trial had with that particular outburst of yours. Go ahead, try it, Owens, but absolutely remember, when your client fails to get a new trial and everyone continues to think you are a boil on the butt of humanity that needs to be lanced, allegedly in Minecraft, and it's really only your soul that kinda sucks at this point and your attitude. Probably work on that. But honest to God, Owens, seriously, this is what you're going to put in? This is one of your arguments? This is the most soulless, disgusting, lacking of empathy piece of crap. You have a wholly unlikable client, and you are making yourself wholly unlikable just to match her energy, I guess. I hope, because I would hope that a practicing, well-seasoned attorney would realize that emotions are hard to handle, that sometimes in these despicable cases, people, think they're okay with something, but they're actually not. And honest to goodness, George's family did their absolute freaking best to try to get out of that room as quickly as possible to not cause a scene. You entitled butt monkey, and, apparently just curling up with the thunder cunt herself. Excuse me, sorry for that rant, but I have never been more irritated than when he did that and pointed at George's family like that. Prior to jury deliberations, the victim, not the alleged victim, again, your client is guilty for right now, so he is the victim. The victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions. Owen, did you ask for a curative instruction? Did you maybe want to print it out on a big sheet of poster board, possibly charge $400 more to whatever, future piggy bank that Sarah Boone's going to pay into? Whether or address whether the outburst would adversely affect the jury's deliberation. Florida appellate courts have held that a failure for the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. See Nebergall versus State, Smith versus State, and Collin versus State. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made under controlling precedent if the defendant is entitled to a new trial. Owens, you seem to be able to flap your gums and complain and, ask for a continuance and all this other, sundry and ridiculous stuff. You couldn't have asked for a curative instruction. Did that just slip your mind? Were you trying to, combobulate your closing argument, and that's why you couldn't do it? Argument 4, the court erred in not allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. No, the state didn't know that she had changed her thinking about this either. This was not state shenanigans, and having been covering the, Delphi trial, I can show you state shenanigans if you'd like. But the state was unaware. You had two chances to wadir this woman and try to figure out if she, confabulated with the state and conspiracied all of these things. The state didn't know, she didn't tell them. This point is moot, in my opinion. I'm not a doctorologist, I am not a lawyer, but in my opinion, if I were the judge, out she goes. This issue was discussed extensively in the expert witness's deposition on October the 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. Now, I can't tell if Owens is slow on the uptake or is deliberately misunderstanding that the state. Owens seems to only hear what he wants to hear. He's very much like Sarah. So he seemed to, just completely miss the point when the state continued to say that no, we didn't talk to this witness. This answer was not something we expected. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for justifiable use of force and battered spouse syndrome testified before a jury was improper. Um, Didn't your expert witness, Dr. Penny Problem Glasses from HR, basically give like that George, getting that scary tone and, allegedly and trying to get free of the suitcase were in fact the inciting factor? I don't know. Rules for thee, but not for me. The state's expert, Dr. Tanya Warner, MD, admitted she had not listened to the defendant's testimony before the jury, therefore forming her opinion on this ultimate issue of fact, or before forming her opinion on this ultimate issue of fact. In addition, Dr. Warner failed to listen to the testimony of Dr. Michael Brandon and Dr. Julie Harper before expressing her opinion. Therefore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Morty versus Bethune Cookman University Incorporated. When a witness is asked to express an opinion that applies a legal standard to a set of facts, that opinion testimony is generally inadmissible. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law, Dubin versus State. The testimony may interfere with the function of a trial judge to determine the applicable law and instruct the jury therein. Lee County versus Barnett Banks, Incorporated. Argument 5. Well, let's get to it. The prosecutor committed prosecutorial misconduct by using rebuttal argument to make a second closing argument. You will leave the rebuttal argument out of your mouth, Mr. Owens. We use the force, we like the tie, and he just kicked your butt, and that's why you're upset. The state committed prosecutorial misconduct by essentially making a second closing argument instead of rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. Wherefore, premises considered, the defendant seeks the relief sought herein as well as any other relief she may be entitled to. Defendants requests a hearing on this matter. God, please let the state spank this man and Sarah in full court, and let me giggle all the way while using the C word. Well, there you have it. Sarah and Owens are, again, let's just do it, the world's smallest violin for their suffering. I am sure that the state is going to basically just, smack them down with all sorts of case law. And Judge Cranick is going to go, we're still going to have sentencing on December the 2nd. Go ahead and prepare for that. Hope you enjoy your pretrial, your pre-sentencing, I guess, investigation, Owens. And my guess is he's not doing a pre-sentencing investigation because he's too busy working on, I'd like a new trial. It was unfair. Well, let me tell you, sir, life is unfair. Sarah, life is unfair. Putting someone in a suitcase and leaving them to die is unfair. You know, videotaping them while you treat them like a dog is unfair. Ripping up their birth certificate is also unfair. God, it swings and roundabouts, doesn't it, Sarah? Karma's a bitch. Bye, you guys. I will see you in a little bit. I'll be on some election streams and, safely in my room, hiding away from the world. Bye, you guys. Have a great day.